Welcome everyone. Thank you very much indeed for joining us at our Education Employment Law update today. Obviously we're living in very strange and difficult times at the moment that put the sorts of things that we do day to day very much in perspective, but I guess that all that we can do is plough on at the moment. Anyway, just to introduce myself, I'm Judy and I'm an employment lawyer at Mills & Reeve, and I'm joined today by my colleagues Alex Curnow and Abisola Latunji-Cockbill. We are all employment lawyers at Mills & Reeve, and we all specialise in advice to our education clients. Just before we get into the meat of our webinar this morning, just some housekeeping points. I've put those on the next slide, just to cover a few things. So just be aware that we are recording this session. Your cameras aren't on for us, so you're not being recorded, but the session is recorded with the idea that we'll make it available afterwards. Do feel free to ask questions or indeed make comments in the question and answer box, which you should see on your screen. We've got a really full programme this morning, so I can't promise that we'll answer everything or maybe even most of the questions, just depending on what we get. But as far as we can, we'll try to pick up on a few points that are coming through. So do feel free to type into that. We also have a poll question for you, which we'd be grateful if you would answer. And finally, there's a feedback survey, which will pop up, I understand, automatically as if by magic at the end of the session. And we'd be really grateful if you would fill that in for us so that we can try to make sure that we consistently improve and deliver what you're looking for. So with that, just moving on to what we will cover today. So in terms of our agenda, which we've got on the next slide, is well, we've got five topics, which are the implications of COVID for working arrangements. And then we've got three update sections. There's an equality law update, unfair dismissal, and industrial relations. Industrial relations in particular is something that is close to the hearts, I'm sure, of quite a number of our university clients that are here. And then some other key developments with a bit of horizon scanning. So as I said, a full programme. So starting off with our first topic, which is the implications of COVID for working arrangements, and a quick update then on where we are on COVID-19. So the headline point, of course, has to be the Living with COVID plan, which the government announced on the 21st of February. I'm not going to go through what's in that plan in any detail. I'm just going to pick out a few key points and make some observations around it. The first main point is that the legal requirement to self-isolate ended on the 24th of February, and free universal testing will end on the 1st of April. Also on the 1st of April, the government will publish more guidance and replace its current working safely guidance. So in effect, we're in a transition period until the 1st of April, whilst we await the full, more general government guidance, and also the impact of removing most of the restrictions is being assessed. I think, and sort of from what I can pick up, that in that period, most employers will probably be looking to retain and continue their current protocols. And, in any event, of course, it's important to remember that notwithstanding the lifting of restrictions, employers still have all their legal obligations to provide a safe system of work and a safe workplace in accordance with health and safety requirements. And in particular, that will involve ensuring that the necessary risk assessments are done, particularly in relation to any vulnerable people. After the 1st of April, it looks like what in effect is going to happen is that the clock will be turned back to take us back to where we were before testing was widely available, and the emphasis was really around controlling the behaviour of people with symptoms. So as I said, it's like the clock is going back there. In relation to the education sector specifically, the government updated its guidance. It's got separate guidance for HEFE and general education and childcare settings on the 24th of February. The thrust of that guidance is very much about getting back to normal, and in particular getting back to face-to-face interactions and face-to-face teaching. And in terms of what we're sort of seeing across the sector, and also at Mills and Reeve ourselves, is that the direction of travel is towards allowing and enabling hybrid working where particular job roles allow that. So, you know, and I think there's a big piece around a real desire to ensure that workplaces, you know, in terms of campuses, offices, etc., become vibrant places again. So the move to hybrid working obviously will mean that a lot of staff will continue to have more flexibility than they had pre-COVID, but that doesn't mean that it's necessarily going to be easy going forward as people transition to new working arrangements, particularly as people transition to being asked to be in the workplace at least some of the time when they're used to very often working from home. So I'm going to look at two areas. First of all, a couple of cases around staff who don't want to or don't feel able to return to the workplace, and then look at statutory working, flexible working requests, which is an area we think there's going to be a significant increase in over the foreseeable future. So starting off with fear of contracting COVID at work. In this case, X and Y, unusual title, it's because it was anonymized for specific confidentiality reasons, is interesting. X had a genuine fear. Nobody disputed that she had a genuine fear of catching COVID-19 by going into the workplace, which is what her employer wanted her to do. And she was particularly concerned about passing it to her vulnerable partner. Her employer didn't accept that she had a reasonable fear on that basis and refused to pay her. She brought a claim of unlawful discrimination on the ground of philosophical belief. And the way that she put her philosophical belief was that it was a fear of catching COVID-19 and a need to protect myself and others. So the fundamental question that the Employment Tribunal had to answer was, is that a protected philosophical belief under the Equality Act? And the answer to that question was no. As you might remember, there's been quite a bit of case law, in particular one case which identified 5 key criteria which had to be met in order for a philosophical belief to be protected. X fell down on 2 of those necessary criteria, in that the tribunal held that her belief wasn't really a belief, it was more a reaction to fear, and you know, reflected a widely held opinion in the population rather than being a belief. And also, secondly, that her concern was about herself and her immediate relations, you know, people around her, rather than a more general, substantial belief relating to the world at large. So for those reasons, it was held that she didn't have a protected philosophical belief. So it's a helpful case, I think, for employers where you're met with somebody who's expressing these types of concerns. But a couple of words of warning: it's an Employment Tribunal judgment only, which means that it doesn't comply other tribunals to follow it. And also you do of course need to be aware of other Equality Act protected characteristics that could be relevant in this type of situation. So that's fear of contracting COVID at work. And then just moving on to the area of indirect discrimination, and a case called Follows and Nationwide Building Society. I mention this one because, and I don't know if we can get that slide up or if we're having a problem with it. It's an important case because for the first time, the UK Employment Tribunal has upheld a claim of indirect rather than direct associative discrimination. So as you will remember, direct associative discrimination occurs where, for example, an employee is passed over for promotion because they are good friends with somebody who has a protected characteristic. So, for instance, they might be good friends with a gay person, let's say. Indirect associative discrimination occurs where an employee is put at a substantial disadvantage due to their association with a person with a protected characteristic. The Equality Act allows direct associative discrimination, but not specifically indirect associative discrimination. What's important about this case is the Employment Tribunal interpreted the Equality Act in order to bring it into line with EU law. It's part of the retained part of EU law that we have. In Mrs. Follows' case, the Employment Tribunal upheld her claim for indirect associative discrimination related to disability. Her circumstances were that she worked from home because she needed to care for her disabled mother. Nationwide applied a new policy that required her and others in her work type to attend the office. This put Mrs. Follows at a substantial disadvantage because of her association with her mother as a disabled person. Nationwide couldn't show that it had taken steps to alleviate the disadvantage or to consider alternatives, and it couldn't objectively justify the requirement to attend the office. So she succeeded in her claim. Similar to the X and Y case, it's an employment tribunal decision, so it's not binding on other tribunals, but until a more senior court tells us otherwise, all employers need to be aware of the possibility of indirect associative discrimination claims. And I think this is especially relevant at a time when many employers are trying to bring more employees back into the workplace who may have become established working from home, and also to introduce arrangements which may involve different working patterns. So just moving on briefly to the next slide, which is reluctance to attend the workplace, and some top tips around that. I mean, a lot of this will be known to you already, but just to highlight a few points. I think the absolutely fundamental point when dealing with somebody who is reluctant to come back to the workplace is to speak to them in order to understand what the reason or reasons are, because it may well be that there are very good reasons. And of course, you need to be alert to the fact that there could be Equality Act issues in play. If there's been a statutory flexible working request, then of course that has to be dealt with in accordance with the legislation. And finally, one should always bear in mind that provided there's a contractual provision in place, and provided that the employer acts reasonably in all the circumstances, and there are no Equality Act pitfalls, etc. There is a possibility of requiring somebody to attend the workplace and taking disciplinary action if they fail to do so. So just some things to think about there on reluctance to attend the workplace. And then moving on to statutory flexible working requests, which is the next slide. Most employers are expecting, and I think we expect most employers to see more flexible working requests coming up as we adjust post-COVID. A few points to highlight there. I think the headline is be prepared for more requests. And in the light of that, think about, does your flexible working policy need to be adapted? think about whether you have the necessary arrangements in place to deal with a potentially high demand. And in that context, one absolutely key thing here is going to be around ensuring that there's a consistency of approach in relation to requests. And what we're seeing is a number of our clients, particularly larger clients, are putting in place one panel to deal with all flexible working requests, to ensure or try to ensure that there is that consistency. And also do bear in mind that it will be harder to reject some flexible working requests now, because we've had 2 years of people, for example, working from home. So, so there's something to think about there. And then finally, just to flag, of course, that if a flexible working request is declined, it won't necessarily only trigger compensation of 8 weeks pay under the regulations, but if there's an element, for instance, of indirect discrimination, for instance, unreasonable agreement to allow a request relating to dealing with childcare responsibilities, then that potentially takes the cap of compensation. And there's been a recent case where nearly £200,000 awarded under the discrimination heading for failure to deal appropriately with a flexible working request. And then finally, on the next slide, just looking ahead to government proposals. Government has been consultation recently closed on proposals to amend the right to request flexible working, really quite sort of fundamental changes proposed, in particular the idea that it could be a day one right, and allowing requests for temporary changes and more than one request in a year. So I think there's something there very much to watch this space on the right to request flexible working. The direction of travel is very much towards making it the default rather than something that is unusual. So that's the end of my section on working arrangements, and I'll hand over to Alex Curnow on his equality law update.
Morning, thank you, Judy. I've got a lot to cover on the equality front, so I'm going to kick off with pay gap reporting. So these regulations came into effect in around about 2017. And built into those regulations is an obligation for the government to review the effectiveness of them in 5 years, which brings us to next month now. Purpose of the review is going to see how much change and effect they've had on the gender pay gap, whether they're fit for purpose or whether they need to be amended. And I think amendments are probably likely. I think in the first instance, when they came into force, there was quite a big hoo-ha. A lot of press and industry attention was given to it. Also, likewise, in the second year, a lot of attention was given to those that went up or those that went down in terms of having a bigger pay gap and those that having a smaller pay gap. And I think that press attention and interest has really tailed off. So I think there might be a slight revamp to it to a certain extent. And in fact, even in 2018, the government sort of started indicating some changes they thought they might make. And some of those changes, for example, were to extend the sizes of organisations to which it applies. So at the moment, you need to have 250 employees, but thinking of reducing that to 50, and that will obviously encompass a much broader spectrum of employer or organisation. And also, a lot of organisations do it anyway. They print a narrative explaining the gender pay gap and why that is. I think they're considering, certainly one of the recommendations was that would become mandatory. So we would all be doing that because we have to, rather than because we're trying to control the message around it. Another point was also that at the moment we have to give information based on quartiles, so the bottom 25%, the lower bottom 25%, and then so on. That is a little bit like a rough analysis, and I think that one of the recommendations that I think would also probably be most effective is pushing that into deciles, so 10% increments, and getting a much more finer grain level of analysis from that. And there's a lot of the narratives that people have issued with gender pay gap reporting, where they we use the fact that the 25% quartiles are quite broad to explain certain discrepancies, such as different styles of jobs and work and things like that. Then I think there's also a couple of things on the horizon that certainly have been raised in Parliament or by government bodies or certainly by charities. The first one is, the first one on the slide is the ethnicity pay gap reporting. There's no legal obligation to do that at the moment. Some employers do it as part of their EDI strategies, but you've got carte blanche as to the way in which you do that. So you could do it along in a similar way to the gender gap if you wish, but you're not obliged to do so. You could do it another way. I think that there is a push towards it. There's the Women and Equalities Committee in Parliament. I think it was only last month they released a report recommending that becomes mandatory from April next year. So that could be quite soon as well. And the other one is disability pay gap reporting. There's no legal requirement to do that either. But in July last year, the government published its national disability strategy. That was all very interesting, but then they didn't consult on the national disability strategy at all. And there has been a court case in the High Court declared that the national disability strategy was unlawful because of the lack of consultation. So they're going to have to go back and do it again, the consulting on it, and it could change if we think that they will take into account any of the responses they get to that consultation. That's looking ahead. Looking back, this is a case in the Employment Appeal Tribunal about discrimination arising from disability. Gray and the University of Portsmouth, so we're looking education specific. And this is a case where the Employment Tribunal found that there was a really clear case that the university was acting in a proportionate manner. And the Employment Appeal Tribunal essentially overruled that and said that doesn't make sense. So what happened? Mr. Gray was disabled, an employee, and he was off for 2 years. So he was absent due to illness for 2 years. We all know that's an incredibly long time to have someone on the books. Whether they're exhausted sick pay or not, having a role that is being taken by an individual who has not been at work for 2 years and there's no prospect of returning to work is really difficult. Generally, you've got that role because you need someone to fulfill the duties, and obviously Mr. Gray was not doing that whilst he was off. So they instigated a capability process and they dismissed him by reason of him not being able to carry out his duties. So when we are looking at discrimination arising from disability, it is lawful for you as an employer to discriminate against your individuals, provided it is a proportionate means of achieving a legitimate aim. So here they were dismissing him because of his illness. His illness arose because of his disability. So that is, on the face of it, discriminatory. However, the university said that that's proportionate given the 2 year circumstances. The Employment Tribunal basically said it's obvious that it's proportionate. It's obvious, it's clear. You can't have someone employed for 2 years and not have and not be working. But they didn't give it that much detail. And that was a little bit of an error by the Employment Tribunal. So it's partly a technical point in litigation. But I think the key point here is that when we're looking at in Employment Tribunal cases, we're looking back to see what was the decision made at the time and why. And I would hazard a guess to say that the dismissal letter for him didn't tackle that point. It didn't have any information to say, this is why we think this is proportionate. These are the issues it's causing us. It's probably more a matter of saying, we can't have you in employment anymore. And that simply wasn't enough. And had there been more detail to that, in the documentation at the time, the employment tribunal would have referred to it. It would have been very clear and obvious why they made their decision. And as it is, because it went to the Employment Appeal Tribunal, they have allowed the appeal and it has to be heard again. So they are going through this litigation once more, having already dealt with the case, which is quite frustrating to have to do it twice. Another topic that's really big, particularly it's big across the board, particularly in education, I think, is the menopause. And this is a particularly interesting case, Rooney and Leicester City Council last year, where there were some really common menopausal symptoms related to a disability. I'm not going to go through necessarily the details of that case, but I think it's illustrative of the difficulties we are starting to face. We've been facing them more over the last couple of years, get more and more menopause related claims. But I think the difficulty from an HR perspective is that we're going to have more women than ever in the menopause age who are at work. There is a perhaps strange taboo attached to the menopause and talking about it at work, and it really isn't something that is commonly discussed at work, or is not something that people feel open and able to talk about in the workplace. And that's something that various institutions, various bodies have said really needs to change. So by way of an example, I think it was CIPD research. They found that although the effects they conducted some research, and 65% of women within the age said they experienced a lesser ability to concentrate. That's something that certainly I take for granted, my ability to concentrate, and it's not necessarily the first thing you think of when you've got an employee who's making small mistakes, and unfortunately, a male line manager is probably not thinking about menopause symptoms, getting mistakes from a junior beneath him, and is wanting to take some kind of disciplinary or performance action against them. Well, that may well be something that is, on the face of it, discriminatory because of either a gender, or it could be a disability. But it's not just ability to concentrate, as we all know. CIPD research, just some interesting factoids for you. 48% said they feel more stressed, and 52% said they feel less patient. And I think it was 1 in 4, so 25% said that they felt comfortable raising the fact that the menopause was contributing to their sort of poor performance or issues with work, attendance, or anything like that. So that means that for every one person that raises it, there are 3 other people who are essentially suffering in silence, which isn't really acceptable, and something that we really need to change. The slides comments there about some of the duties you need to think about. So the specific symptoms may amount to a disability for certain periods of time. So that means it triggers your duty to make reasonable adjustments. And it's always difficult when you do get a tribunal claim come through, if the underlying cause for any of for the poor performance or for the ill health isn't properly addressed and isn't properly identified. And so if we go back to what I was saying a moment ago, we're looking back at the decision that was made at the time and the factors that were taken into account at the time. If there was no investigation and no appreciation at the time that menopause was causing it, then it's very difficult for you as an employer to say, yes, we took that into account, because you can't take it into account, of course, if you're not aware of the issue. And of course, the comments related to menopause may amount to harassment, and there's a wealth of cases over the last few years that show some really beyond insensitive, actually, comments, usually from male colleagues, relating to the menopause as well. Another issue that's really focusing on the education sector at the moment is the clash of rights. And I put these two cases up there because they're really illustrative of how difficult they are. And this is essentially a clash between freedom of speech, freedom of expression, and but mixed in with some potentially controversial rights, so viewpoints or opinions on things like biological sex, and that's been a really difficult one in Forstater. So by just as a recap, Miss Forstater, she had some beliefs that others felt were transphobic, and she brought an employment tribunal claim in relation to the way she was treated. She said that her beliefs were a religion and belief under the Equality Act. The tribunal initially said, no, because we don't agree with you, essentially. We think that your belief is not suitable for protection in a democratic society. Because for it to be a religion or belief, it needs to be worthy of respect in a democratic society. The Employment Appeal Tribunal overturned that and fundamentally said that it was capable of protection, and that we don't have to agree with all views that everyone shares, but there has to be some recognition that there are different, sometimes polar opposite views. And Lee in the United Kingdom, that is the Lee and Asher Baker case that we've been talking about for a few years now. That's also known as the gay cake case. Essentially, they tried to appeal to the European Court of Human Rights, but then the European Court of Human Rights refused to take on the case because they didn't raise issues of European law throughout the proceedings. They only raised it at the end. But the key point here is that in that case, you've got the Baker, who had particular views about, Christian views about not wanting to print messages in support of homosexuality. And then you have Lee, who obviously felt that he was discriminated against as a result of that decision, and both of them have got competing rights. But this is something that is also featuring not only in the context of employment tribunal cases, but there's also a lot on the sort of reputational and just general employee relations front. There's some sort of pointers at the bottom of the slide there. Kathleen Stock was a University of Sussex professor in philosophy, and she resigned following accusations that her views on gender identity were transphobic. And in fact, the UCU in that case had taken quite a key part in instigating the sort of general consensus of opinion against her at the university. It was also started by a series of students as well. So you're getting pressure from all fronts, where you've got pressure from students who are ultimately the primary customers in so many senses, as well as from UCU and from other colleagues. She was given, so this was last year, post her resignation, she wasn't, you may say this is a recognition of her position, you may not. She was given an OBE, Services to Education, and 600 academics wrote to complain about that, and then 400 or so wrote in support of it. So what you find is you've got very highly educated individuals who are taking polar opposite views, quite fiercely opposite views on these, which is where the clash really does come. At the University of Essex, that's a reference to Professor Joe Phoenix, who was, some may say, a victim of cancel culture, in that he was due to run a seminar at the University of Essex. They cancelled it, and because of some fears for safety reasons, a lot of students said that they were going to blockade the seminar room at the time. They said then they would re-invite her back, but subsequently said no, they wouldn't re-invite her back because of her views. And they had an independent investigation from that was carried out by a very experienced discrimination barrister who found that both instances were unlawful. So essentially they should have properly managed the unrest. They said they should have not have cancelled the initial seminar, and also that it was unlawful for them to cancel the invite at all. And perhaps, if I can highlight this, is probably the clearest or most difficult clash. So you've got Stonewall on the one hand, the charity set up many years ago to push forward and fight for, it wasn't necessarily this white broad back then, but it's now LGBT rights. And they are currently at dispute with the European, sorry, they are currently at dispute with the EHRC about what views they should have on transgender and gender identity rights. And for example, Stonewall have recently released their workplace equality index. Mills and Reeve came 110th-ish or something, which means we've obviously got work to do, but it's very good to be there. But what you did notice is that things like all government departments have not put in any information and refused to take part. But you've essentially got here two of the key equality organisations who are at loggerheads about where the position of rights should be, and where the position should sit in relation to that clash. And if they can't agree, then it really does show that it is something very, very difficult for us to look at indeed. And I think certainly in universities, decisions on things like that are being taken at the top level, vice chancellor level, in most cases. So that is my quality sort of update. And now I hand over to Abisola, who's going to talk to you about dismissal and industrial relations.
Thanks very much, Alex. So as Alex said, I'm going to look at two of the sections for this webinar. The first one, you'll see that the title slide was deliberately a bit ambiguous in referring to cases considering dismissal, for reasons I'll come on to. And then the second section I'm going to look at is a bit of an industrial relations update, which is obviously very pertinent in the sector at the moment. So starting with dismissal related cases, and as I say, that's deliberately ambiguous because the first of the cases is an unfair dismissal case. The second doesn't refer to or doesn't relate to unfair dismissal, but is equally, if not more important. But turning to Altairs and the University of Essex first, and as with one of the cases that Alex looked at, you'll see that this is another sector-specific case, which I always think is helpful and will therefore hopefully be particularly interesting to those of you in the higher education sector. And the Altairs case considered the important question of dismissal of an academic during her probationary period, and the question as to whether the institution was able to dismiss Dr. Altairs before the end of her probationary period in circumstances where the ordinance didn't cater for that specific situation. So as will be familiar to many of you, and as was the case for Dr. Altairs, her employment contract incorporated the relevant provisions of the university's ordinances. And those ordinances contained provisions, again, as many of you will be familiar with, which limited the circumstances in which Dr. Altairs' employment could be ended, and it defined the circumstances in which termination would be justified and when dismissal would amount to good cause for ending the appointment. Now, again, not unusually, Dr. Altairs' employment contract had a 3-year probationary period. So we're talking about a fairly lengthy probationary period, which is relevant for reasons that I'll come on to. And the ordinances set out, as you'd expect, the procedure for confirming her appointment, including the procedure that the university needed to follow if it wished to confirm her in post before the end of the probationary period. What the ordinances, what both the ordinances and the employment contract didn't deal with was if and how the university could end the probationary period early, and if so, whether it was able to do that under the provisions dealing with probation, or whether it needed to enter into the process which would end her employment for good cause. And ultimately, what the Employment Tribunal and Employment Appeal Tribunal had to look at was a matter of contractual interpretation, because looking at the capability procedure, the annual review processes, the ordinances and the employment contract, there weren't any express provisions which allowed the university to terminate Dr. Altairs' employment early during the probationary period. Notwithstanding that, and helpfully so, the Employment Appeal Tribunal found that applying the normal rules of contractual interpretation, it must have been the intention of the parties on entering into the contract that the university would be able to end probation early, and that accorded with good employment common sense. So whilst that would have clearly been a welcome decision for the university, because it meant that it didn't have to go through the good cause dismissal process to effect early termination during probation, I think this case is a really helpful reminder that, you know, whilst employment contracts and relevant contractual documents, which can span over a number of different documents drafted by different people at different times, whilst those documents can't cater for every potential eventuality, there are certain circumstances that you would ideally want to be explicitly covered within those documents. An early termination during a lengthy probationary period is one of those. So as I say, it was the right decision and a helpful decision, but perhaps a helpful reminder to regularly check through the contractual documents that apply to academic members of staff and indeed other members of staff, and make sure that they have adequate provisions for circumstances that will commonly arise in practice. So moving on to the next slide, which is the second case that I'm going to look at. And as I alluded to earlier, this isn't an unfair dismissal case, but it is a particularly important case which relates to dismissal. And it covers the important area of circumstances in which an employer might seek to dismiss and re-engage staff as a method of trying to enforce new terms and conditions of employment. This is a very recent judgment, so it was handed down last month. And it's the case of Union of Shop and Distribution and Allied Workers, so the UDSOR union against Tesco Stores Limited. And just taking a kind of contextual step back, as you'll all be familiar with, in circumstances where an employer is seeking to change terms and conditions of employment, there are a number of steps that the employer might engage in to try and affect that with varying levels of desirability. So clearly the most desirable way of affecting changes to T's and C's is to try and get agreement with the relevant employees. In circumstances where that's not possible, you may be able to rely on a general or a specific flexibility clause in the contract to enforce the change. Taking that one step beyond, you might seek to unilaterally impose the changes and hope that the employees accept those changes and don't work under protest. And as is what is usually a last resort, if it is particularly important to get the changes through and you're not able to agree them or otherwise impose them, then you may need to or may choose to dismiss members of staff and offer them re-engagement on new terms and conditions of employment. So coming back to the specific case at hand, the relevant employees at Tesco had an arrangement which was known as retained pay. And that was effectively pay protection on a permanent basis, and the permanent nature of it is important. And that retained pay increased every year, and it was agreed in 2010 after a number of years of negotiation in exchange for the employees agreeing to relocate and to give up their entitlement to redundancy payments. And it was very important in this case that there was a collective agreement, as I said, agreed in 2010, which detailed these agreements between the union and Tesco. And there was also a lot of, I guess, internal publicity and communication around the agreement, which made clear that the retained pay would apply on a permanent basis and it couldn't be removed without mutual consent. And it would continue to apply to the relevant employees on a permanent basis, so long as they remained in post. So perhaps as you're predicting in relation to this case, it got to the point in January last year, so January 2021, that Tesco announced its intention to buy out this entitlement in return for a one-off payment, which was equivalent to 18 months retained pay. So Tesco got to the point where it no longer wanted to honour this retained pay arrangement and sought to agree something in exchange. But ultimately, Tesco said that if staff didn't accept the offer, then they would be dismissed and offered re-engagement on new terms. So notwithstanding the fact that the retained pay had been agreed on a permanent basis, Tesco's argument was that, notwithstanding that and notwithstanding that there was effectively a contractual entitlement to retain pay on a permanent basis, that couldn't override Tesco's contractual right to end employees' employment, provided that it gave the required period of notice. So UDSOR and 3 employee representatives brought injunctive proceedings to the High Court to try and stop Tesco from being able to dismiss staff in order to effectively remove the entitlement to retained pay. And in what is quite a, I guess, rare judgment, the High Court did grant an injunction to prevent Tesco from being able to dismiss staff. And in doing so, the High Court decided that whilst these were exceptional circumstances, it could imply a term into the employee's contracts of employment, which meant that Tesco's right to dismiss employees on notice couldn't be exercised for the purpose of removing or diminishing the entitlement to retained pay. The reason for that was that otherwise the entitlement to retained pay couldn't properly be said to be permanent, which is how it had been expressed in the contractual documents. And it was also relevant that the change in terms would have reduced a significant proportion of the remuneration payable to those affected employees. Now, what that judgment didn't mean is that Tesco wasn't able to terminate the employee's employment for other legitimate reasons. So if there was a redundancy situation or if there was an instance of misconduct. But that said, in the circumstances where the employees had this particular protection against dismissal to remove retained pay, it was also the case that any decision to dismiss employees would likely be closely scrutinised in order to ensure that the genuine reason for dismissal wasn't in effect to remove the retained pay. So I think that the lesson from this case is probably fairly self-evident, which is that in circumstances where an employer is going to be seeking to agree long-term benefits for employees, it's really important to make sure that they're framed in a way that not only addresses those specific circumstances at the time, but perhaps also looks forward to times that may be slightly different to the context in which they're agreed. And the fact that the retained pay was said to be permanent in such clear and ambiguous terms is really what caused difficulty for Tesco in this situation. And I think I can have some sympathy for Tesco in that agreements between unions and employers are often agreed at a time where it's done with the best of intentions and it's not necessarily foreseen that circumstances may change. And as I mentioned at the beginning, a proposal to dismiss and re-engage is fairly, it's often referred to as the nuclear option. And it's therefore not something that employers enter into lightly. But notwithstanding that, it's really important, I think, for employers not to unduly fetter their ability to do that should the circumstances require them at a later stage. So moving on from dismissal related cases, I'm going to look at an industrial relations update. And I'm conscious that, this is a topic which, as Judy mentioned earlier, is particularly pertinent in the sector at the moment. I know that a number of you will have had strike action and action short of a strike over the period from mid-February onwards, ending yesterday, in relation to both the USS pensions dispute and the full fight over pay, workloads, casual contracts and pay gaps. And I think, all of that is to say that we're in a climate of increasing industrial unrest at the moment. And that therefore makes the kind of very recent cases that we've had on industrial relations even more pertinent, even more relevant, and something which is contributing to the kind of matrix of what is a particularly complex area of employment law. So you'll see reference to two specific topics on the slide. And I'm not going to go into the facts of the cases in too much detail, but really just to talk through the recent principles that we've got and what that therefore means for you as institutions. So the first case referred to on the slide is Costal and Dunkley, and that considered the operation of Section 145B of the Trade Union and Labour Relations Consolidation Act 1992, also referred to as TULCRA. And as many of you will know, the purpose of Section 145B is to deter employers from offering inducements to workers in order to bypass collective bargaining. And to put it in really brief terms, what Section 145B does is that it provides that a worker has an entitlement where they're a member of a recognised trade union, not to have an offer made to them where if they and other employees accepted that offer, that would have the prohibited result. Where the employer's sole or main purpose in making that offer is to achieve that result. And the prohibited result is that the worker's terms and conditions of employment would no longer be determined by a collective agreement negotiated by or on behalf of the union. And the specific principle considered in the Costal case was whether for the purposes of Section 145B, an offer made by an employer effectively to bypass collective bargaining on a specific and single occasion breaches the requirements in section 145B, because you can see that there are different circumstances in which an employer might make an offer to employees which overreaches collective bargaining. An employer could do that in a way which brings an end to collective bargaining as a whole, or an employer might do that in respect of a specific round of pay negotiations, for example, which doesn't affect the union's ability and the union's entitlement to affect collective bargaining with the employer in the future, but it has an effect in respect of that specific round of, as I say, pay negotiations. And in the Cockbill case, and I have to say that the decision went different ways at different instances, but the decision of the Supreme Court, which overturned the Court of Appeal decision, was that section 145B does apply, even if it's made in respect of a specific negotiation and it's not seeking to overturn collective bargaining with that union as a whole. And I think that that's a really important point, because when it was heard in the Court of Appeal, the Court of Appeal was concerned that by taking that interpretation, it effectively means that the union may be in a position to veto any particular pay offer and prevent the employer from being able to appeal directly to employees. But the Supreme Court found that in any instance where an employer is effectively putting an offer to employees directly that would otherwise be dealt with by way of collective bargaining, that's a breach of section 145B. And that's really significant because the penalties, as you'll know, for breach of section 145B are significant. So it's around £4,500 per affected employee. And really the kind of takeaway from the Cockbill case is that if an employer is going to make an offer directly to employees, which takes it outside of the scope of collective bargaining, that should only be done in circumstances where, one, there has been a kind of genuine and good faith attempt to collectively bargain with the union. Two, though crucially, those discussions and negotiations have concluded. In the Cockbill case, the negotiations were ongoing, and that was a kind of key part of the downfall of the employer in that case. And thirdly, any offer shouldn't have the effect of overreaching collective bargaining with the union on a permanent basis. Now, even in those circumstances, some of the Supreme Court judges had some cynicism as to whether an employer is even in those circumstances able to make an appeal directly to employees. So it's one of those areas that is particularly complex, and one in which we'd certainly recommend that advice is sought before seeking to overreach any collective bargaining arrangements. And then very quickly, the second two cases on the slide relate to the protection that employees and workers have in respect of industrial action and other trade union activities. And the important point here is that the legislation, so again, TOLCRA, has always made a distinction in the protection that employees have in respect of industrial action and other trade union activities. So section 238A of TOLCRA provides that employees will be automatically unfairly dismissed if the reason for the dismissal is because an employee is participating in official industrial action. So that's action or that's strike action or action short of a strike, which is lawfully called and compliant with balloting requirements. There are then separate sections which deal with detriment. So section 146 protects employees and workers from detriment short of dismissal. So, for example, a disciplinary sanction for engaging in trade union activities or proposing to do so. But historically, reference to trade union activities hadn't been found to include industrial action. And the effect of that was that if an employee was subjected to a detriment short of dismissal for participating in industrial action, there historically wasn't felt to be any protection for that employee because it wasn't dismissal that they were subjected to. The two cases referred to on the slide extend the protection for workers in those circumstances. So in the Mercer case, it was found that where an employee was suspended and given a warning for taking steps to plan industrial action and made clear her intention to participate, the Employment Appeal Tribunal found that, notwithstanding the fact that she wasn't dismissed and notwithstanding the fact that she hadn't participated in industrial action, she was protected against detriment for doing that. And then the Ryanair case, so Ryanair, DAC and Murray, went one step further and said that even where an employee or a worker is subjected to a detriment short of dismissal for taking part in or for for taking steps in relation to unofficial industrial action. So in this case, industrial action that wasn't sanctioned by the trade union. Again, the worker was protected from action short of dismissal in that case. So that related to a proposal to remove certain entitlements. So these cases are really important because they do significantly extend the scope of protection for workers in respect of industrial action, both where it's action which is short of dismissal and where the industrial action isn't official. Both of these cases, perhaps unsurprisingly, are being appealed, and they're expected to be heard in the Court of Appeal later this year. And that will be a really important update because, as I say, given the current industrial action in the sector, employers do need some clarity as to the scope of the protection that workers have in relation to industrial action and other industrial activities. So it's very much a watch this space on that one. But in the meantime, employers do need to take care in respect of any action they're seeking to take relating to employees participating in strike action. So I'll just briefly pass you back to Alex to conclude with a few key developments.
Thank you. I've only got a few minutes, so I'm going to do this relatively quickly. I'm also going to have a pop quiz on this case, Smith and Pimlico Plumbers. I'm going to ask you in a moment if you think it's going to affect you. This is a Court of Appeal judgment from last month, I believe. Essentially, it deals with instances where employees have either not been given or not been paid holiday properly. So there's a very technical calculation for staff, particularly those who rolled up holiday pay or those who are self-employed. Your holiday pay should be based on, if pay fluctuates, a calculation or an average of your holiday over the previous period. I believe it's 12 weeks. But we've always dealt with holiday pay and holiday entitlement as separate rights. So particularly rolled up holiday pay is used frequently in the sector. And what the Court of Appeal have said in this case, in that quote there, is that there's one right, and that the right is to have holiday, and that holiday needs to be paid for when the holiday is taken. So what they could be argued to be saying there is that rolled up holiday pay would then not apply or not transfer to holiday periods. But it's a very difficult point to consider because what the judgment deals with is Mr. Smith, who was self-employed and then argued for his work status and was successful. It doesn't deal with instances where there are contractual or clear arrangements setting out that there is rolled up holiday pay. And the question is whether those individuals who, particularly term time staff, visiting lecturers, associates, they clearly have their holiday. So there's a very clear theme of health and safety throughout the judgment, requiring people to take their holiday. But of course, the education sector will have very different arguments indeed. Will probably be saying that the rolled up holiday pay clearly set out protects them. That's something I think is going to be raised. I think UCU universities have raised it, certainly for some clients. I think that's going to be coming down the tracks. So quickly, if we can do the poll, please. I'm keen to get, I know people are keen to get off, but if we've got just a second, the question is, do you think you're likely to face queries following this judgment? We already have. I think it will arise at some point. Or no, I think we're safe, or this won't make a difference. I think given the time, I think we need to get the answers. Very interesting. Limited already have. Great to hear that some think it won't do, but it's sort of the majority is I think it will at some point. So I think that's really interesting. Thank you very much for being honest about that. And finally, the final point I was going to look forward to, if I could move the slides, was the employment bill. I'm going to whiz through this like I'm Martin Lewis, and other money-saving experts are available. But we're expecting changes to flexible working framework, perhaps making it a day one right, and also expecting extended protection for redundancy and dismissal for new mothers. And there's some equal pay issues to think about as well, but I won't go into them in detail because they're about separate establishments generally, and the education sector. The unions will be keen to see if they can leverage that, but I can't see a clear way for them to do it for most education sector clients. And so I've also actually got a question, so I'm going to answer it if that's okay, Judy. I had a quick question on menopause. What happens when men of a certain age start to say their absence of performance is age-related, things like lack of sleep, difficulty concentrating, low mood swings, forgetfulness? Could that be a potential case of direct discrimination related to age rather than disability? It potentially could. I think that for that to get to the point where it is bad enough that there are performance concerns, I think you would be looking at some kind of capability issue there as to whether they're capable of performing the role. It could do. I think it was more difficult because there's, so far as I'm aware, there's no menopause for men. So there's no sort of link that you can create between those kind of symptoms and a known condition for men in their later years. And so it's probably less likely to receive sympathy from a tribunal panel, but it's not completely impossible. And of course, you'd look to justify it.
Thank you very much, Alex. I think there are things around the sort of male menopause which are sort of potentially an issue. But I've been answering my questions on the Q&A as we go along. I don't know, Abisola, if there's anything that you just want to pick up on the question and answer, or have you answered? Have you gone long? Or
I've been typing away answers to those.
Okay, right. That's so I think we've done our best in terms of typing answers, and Alex has come back on one. Thank you very much. So with that, we're 2 minutes over time, not too bad. Thank you very much again for joining us. Please do fill in the feedback request form, which should pop up, I understand, automatically. And we hope to see you again before too long. Thank you very much. Bye-bye.